Your MSA is one of those core contracts that you need to have in your small business, especially if you're an MSP. Not sure what an MSA is? This video is for you. Your MSA, or Master Service Agreement, is that contract that defines your working relationship with your client. Your MSA helps you by providing standard sets and guidelines about how you're going to do business with each other. Because if you've watched any of my other contract related videos, your contracts are all about setting expectations and making sure you and your clients are on the same page when it comes to all things doing business together. It's important that you have one defined, executed, and in place. Without an MSA in place, it opens you up for all kinds of challenges if your client decides they want to sue you for whatever reason. On today's video, I'm going to talk about a couple things. One, I'm just going to do a little bit more definition around what an MSA is and how it's used, and then I'm going to give you the top 6 components that need to be in your MSA in order for it to be effective. So let's head out in today's ramble. As I mentioned before, your MSA defines how you do business with each other, but this is not the place for all of the things as it relates to the different services you provide. Those are going to be in separate attachments or statements of work. Every attorney does it a little bit different. The idea is that you don't have this real long contract that talks about all the different stuff your MSA has plus all the services in one big document. This big monolithic thing can be really hard to review, defend, and just frankly manage. One of the things I want you to do or consider is to modularize your contracts in that have an MSA and then have all these other different pieces of your contract stack. That's an important concept, is that your MSA is just the relationship defined document. It should be noted that I am not a lawyer. This is not legal advice. I'm here talking to you to tell you a little bit about some things that you need to be mindful of in your contracts, but ultimately you need to talk to a lawyer about your specific legal situation. All right, so let's get into the top 6 clauses that you should have in your MSA. Clause number 1 is limitations of liability. Limitation of liability is one of those clauses that is really important to have because without it, the liability limits can be essentially unlimited, and that's not a thing that you want. Now, you can't make your limitations of liability like $500 and good luck, guys. That's not a thing that will work. So your limitation of liability needs to be something that's reasonable and should be sort of in line with your insurance coverage as well, right? So if your limitation of liability says, it's a few grand and you've got insurance policies for a couple $1 million or something like that, that's going to cause some issues. I like the idea of making it relative to the contract size, right? So if your smaller contracts have a smaller limitation of liability and your larger contracts have larger limitations of liability. Oftentimes what you'll see is the preceding 3 months of service or 6 months of service or like $10,000, whichever is greater, something like that in your limitations of liability. But it's important that you have a limitation of liability that is enforceable and that doesn't get struck down by a judge should you ever get sued. The second clause is termination. And by termination, I mean you want to make sure that your MSA can't be voided and shut off while you still have all these other contracts in place with your clients, right? If you have other statements of work, other things like projects going on, you're doing managed services, you have any of those other things in place, your MSA needs to be in place and in power while anything else is happening, right? So said differently, you can't cancel your MSA and still have all these other things in place. As long as you have a clause in your contract that says essentially that, I think you're doing all right. Number 3 is prevailing party. When you have a prevailing party clause in your contract, that means that if one party is to sue another party, the winner of the lawsuit has their legal fees taken care of by the losing party in the lawsuit. Now, why is that important to you? Well, the short version is this helps prevent nuisance lawsuits. This prevents your clients from suing you because they have a lawyer in the family or they are a law firm or whatever else, because the legal fees oftentimes are as much, if not more so in some cases, than the actual judgment in a lawsuit. So by having a prevailing party clause in your agreement, it allows you to make sure that if they're going to sue you, they understand that if they lose, they are on the hook for your legal fees. Now, the flip side of that, if you are the losing party in a lawsuit, you're going to be on the hook for legal fees as well. But I still think this is a smart way of doing things. Like I said, preventing these nuisance lawsuits is important. If you're getting value out of this content so far, please do me a favor, click that like button. Number 4 is scope of services. Scope of services is really important because it says that you aren't going to do things for a client that you haven't been agreed to in writing. The reason why this is important is that if a client declines a thing, especially something like MFA or something that's really important from a security and risk perspective for the client network, that they can't ever expect that you're just going to do it because you thought you should, right? The idea is that if it's not written down and not agreed to in writing, you're not doing it for them. Now, all of that agreement to the writing stuff, it lands in different scopes of work, but this clause here basically just kind of covers your rear on the idea that you're not just going to do things without it being written down. Number 5 is all about non-solicitation. You don't want your clients to be able to hire your people. Similarly, your clients don't want you to be able to hire theirs unless you agree to it in writing, right? Everything needs to be in writing. It's a contract. Non-solicitation basically says that your client can't hire your person unless they pay you for something like 12 months of their salary or $100,000, whichever is greater. And it works in reverse as well, or I like to see it work in reverse as well, because if you make your contract too one-sided, it's going to create all kinds of red flags anyway. The idea here is that you've got some smart people that work for you. It's expensive for you to have to hire somebody new. And so if you have a non-solicitation that is too low, say like $10,000 or $15,000 or something like that, that's cheaper than a placement fee. So make your non-solicitation painful enough where that they're either paying you a hefty sum to hire your person or it prevents them from doing it. Now, you always have the opportunity to waive this, right? So let's say they come to you and they say, we really want to hire this person, and you're okay with it for whatever reason. You can always write a one-time waiver that says, hey, you know what, we are willing to, in this case, let you hire our person. That's totally fine, but again, it's all above board. That's what this non-solicitation clause helps prevent. Number 6 is assignment. Having an assignment clause in your contract allows you to assign this contract over to another party should you sell your business. Assignment basically says that if I sell my business, I can assign these contracts over to the purchasing party and they can do business with you just like I did business with you as an MSP. And the reason why you want to have it in there is that if you sell your business to another MSP or if you happen to be buying one, without that assignment clause in the contract, that means that the buying party then needs to basically negotiate with every single client in order to be able to continue billing without having some potential issues there. So the idea is that you have this assignment clause in the contract so that way you aren't trying to negotiate all these contracts on day one. Now, of course, you want to get any new clients that you acquire through purchase of another company on your own paper, but that isn't the thing that you're going to be able to do in one day. Just make sure that you have an assignment clause in your contract. Otherwise, I would expect the purchase price to be a little bit lower, or that the owner is going to have to stick around and kind of help earn out and convert those clients over to the new party because there's a risk without that assignment clause. There are a bunch of other clauses that you probably should have in your MSA, but these are the top 6 that I thought you should at least be mindful of as it relates to your particular MSA. A couple of questions that people typically ask me about contracts when I'm talking to them about anything legal. The first one is, can I do this myself, right? Do I have to hire an attorney? Well, you can do it yourself, but that doesn't mean you should. I really think you should hire an attorney because there's a lot going on and there's a lot of nuances to the law. And if you grab MSA from here, from this person, and a different MSA from this other service, and you kind of cobble together some stuff, it might work out just fine. But the last place that you want to find out that it's not going to work is when you have an issue or when you're getting sued by a client. So I think it's important that you hire an attorney. The second question that typically follows this question is, do I need an MSP-specific attorney? Now, the answer to the question is no, not really, but you really should. The MSP-specific attorneys, and there are a few, and I'll make sure I link to them below in the description of this video, is that they understand the industry and they've been in the industry for a long time. So they know a lot of the nuances. They know a lot of the case law specific to our industry, of which there's quite a bit. It's important that you find someone who knows this really, really well and you get set up. The reality is you don't have to do a new MSA all the time. This is a thing you do every few years. So yeah, it's going to cost you some money, but I think it's well spent. Now you might be wondering, with all this talk about MSAs, am I likely to get sued as an MSP? The short answer is no, probably not. Most MSPs don't get sued, but the ones that do get sued and the ones that make the news are the ones that don't have their contracts in order. So yes, again, it's going to cost you some money, but it'll help you sleep better at night and help prevent a lot of the kind of nuisance-y lawsuits that might happen, right? That's why all this stuff is important. Make sure you sleep well at night. Make sure you mitigate your risk. Make sure you do the right thing for you and for your clients and for your business. Doing all those things the right way makes things a lot easier on you. Thank you for coming on this ramble with me. Hope to see you on the next one.